Mr. Chapman, good morning.
Good morning, Your Honor.
Was it a tough night last night? You couldn't get out and round up people?
It was a rough night.
Okay. Go ahead when you're ready.
Thank you. John Parker of case 2, James Egan of case 1, Marcus Wright, D'Angelo Gaines, William Amos, Travis Jones, Richard Alviar, Cody Sims of Cody Stinson of Canales Lanza and Christopher James. These respondents failed to appear for their referee hearings. Front of the court requests that bench warrants issue in each of these matters pursuant to statute.
Court would enter bench warrants for Mr. Parker, Mr. Egan, Mr. Wright, Mr. Gaines, Mr. Amos, Mr. Jones, Mr. Alviar, Mr. Sims, Mr. Stinson, Mr. Lanza, and Mr. James as a result of their failure to appear at their respective referee hearings. The court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater. And further, the court would assess court costs of $150.
Thank you, Your Honor.
Okay, you have a good day.
Thank you. You as well. See you, Jesus.
See you Friday, probably. Take care.
We'll see.
We will see. All right, 5 a.m. now. Plaintiff is here by telephone. The defendant is not here.
Okay. Good morning, Mr. Baldwin.
Good morning.
We're going
Your Honor.
to take some testimony from you. So if you would, we'll have you raise your right hand, be sworn in, and then we'll proceed.
Yes, sir.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
And sir, do you have the script that we would have provided you?
Yes, I do.
You can go through that now, sir.
Okay. My full name is Jordan James Edward Baldwin. My address is Battle Creek, Calhoun County, Michigan. I filed a complaint for divorce on 4/17/24. I live in Michigan. I lived in Michigan for 180 days and in Calhoun County for 10 days immediately prior to filing this complaint. When I filed my complaint for divorce, all the statements were true. All the statements in my complaint for divorce are still true today. There has been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. Do I read number 8?
I don't have it in front of me. What's?
Okay, I'll just read it. If there is a female spouse, I am not currently pregnant or my wife is not currently pregnant.
Okay, that's fine. Thank you.
You're welcome. Number 9, the defendant and I have one minor child together. His name is Parker. He's 13. And I have read all the terms of the proposed judgment of divorce and I agree with them. I ask that this court grants an absolute judgment of divorce. Thank you, Your Honor.
Okay, thank you. I'm looking at the proposed judgment. It has what purports to be your wife's signature. Do you recognize that as her signature?
Yes.
Okay. And there's no issues or disputes between you at this time that you're aware of that have not been resolved by the judgment, correct?
Correct.
Okay. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. In this matter, the court has a proposed consent judgment signed by both of the parties. As a result, the court will enter the judgment as submitted. I have done so, sir. You are now divorced. Best of luck to you. I hope everything works out and you're free to go and have a wonderful day.
Thank you, sir. You too.
All right, thank you.
Mr. Vanderhorst, how are you today?
I'm doing fine, Your Honor. How about yourself?
Good. What issues do you believe to be in dispute in the case?
Thank you, Your Honor. I believe the parties will eventually settle all issues, but for now, I want to leave custody, child support, parenting time, and property division as contested issues.
Okay. We don't have the plaintiff here. Is there any reason that you're aware of that the plaintiff is not here?
I'm representing the plaintiff, Your Honor.
Oh, you are? I'm sorry.
Yes.
Okay, that's right. I've got a note here. Mr. Herbstreth, are there any other issues that you believe are in dispute?
No.
Okay. Mr. Vanderhorst, are you in need of discovery in this matter?
Just a brief period of discovery, Your Honor, if we need it. 60 days, I think, would be appropriate.
Okay, we'll give you till January 1. That will more than cover what you need.
Thank you.
We'll have mediation in January, if in fact it's necessary, if you haven't come to a resolution. Mr. Herbstreth, mediation is a process whereby you would meet with a attorney mediator if there are issues that are in dispute at that particular time. If you resolve everything before that, you don't need to, but otherwise you would have to meet with a mediator in January and attempt to resolve any other final issues at that time.
Okay.
Mr. Vanderhorst, who would you recommend as a mediator?
John Brundage?
Okay. Mr. Herbstreth, do you have any problem with Mr. Brundage serving as the mediator?
No.
And who as an alternate?
Lisa McNiff?
You have any problem with Ms. McNiff serving as the alternate, sir?
No.
Okay. Again, if you come to a resolution, then that's not going to be necessary, but we'll put it down just to make sure that we have those particular dates available. We will set February 3rd as the settlement conference date. Sir, that all the parties are required to be here unless we've come to a full resolution prior to that time. Sir, you're going to be getting this case scheduling order, and the order will set forth what processes are going to be going forward as we progress in the case. And there are things that are required in the case scheduling order for preparation for trial if it doesn't resolve. So you'll have to pay attention to those dates because, again, if you don't, it could have adverse effect if you do not comply with those. You understand?
Yes.
So when you get it, read it over, make sure you understand what it is, but there are dates in there that, for instance, witnesses have to be disclosed, property division charts have to be filed, and exhibits, etc. So pay attention to those because those dates, if you miss, they could have adverse consequence to you.
Okay.
And then otherwise, just keep in touch with Mr. Vanderhorst, and maybe you will be able to come to a resolution in this case. Anything else, Mr. Vanderhorst?
Nothing further, Your Honor. Thank you.
Mr. Herbstreth, anything else that you have?
No.
Okay. Thank you. We'll send this out. You'll get it probably in about a week. And again, make sure you note all those dates and have a good day.
Thank you. You too.
Thank
Well, good morning to both of you. This is the time and place set for the scheduling conference. In the scheduling conference, we attempt to put in place a scheduling order, which would, again, outline some of the process and dates and that so the case would proceed in an orderly fashion. First need to ask, and I'll go to Mr. Richardson first because he's the plaintiff, then to you, Ms. Stout. What issues do you believe to be in dispute, sir?
I just feel like it would be in the better interest of the child if she was with me full time.
Okay, so custody is in dispute.
Yes.
Okay. Is that your understanding, Ms. Stout, that those issues remain in dispute?
Yes, I do believe that he is fighting for custody.
Okay. There is a process whereby you can acquire information from another party, and that is called discovery, and the case is relatively new, so what I'm going to do is give you till January 1 for discovery. That will give you sufficient time if you are in need of anything, and you can do that through interrogatories, which are questions that need to be signed under oath by the other party. You can do it through a request for production of documents. You can do it through subpoenas or through depositions or anything else that you would like to do. But you have until January 1 to do that. So don't delay, because I will tell you, the time does seem to, when you do a discovery request, the other party has 28 days to respond. So if you do that, let's say early December, they have effectively until the end of the month. If there was something you wanted to follow up on, you may not be able to because you wouldn't have any additional time. So if you have discovery, you should get that out relatively quick so that we don't have that particular issue.
Okay.
What I'll do is the court will send the matter to mediation in January. And that's the process where you would meet with a attorney mediator and attempt to resolve any final issues if you're not able to come to an agreement prior to that time. There is a cost associated with that because of this attorney mediator that's going to be doing that. I guess I'll ask you, Mr. Richardson, do you have any preference as far as the mediator?
No, no preference.
Ms. Stout?
No.
Okay. Then what we'll do is we'll leave that blank, and then the mediation clerk will assign a mediator. You should be getting notice, I would say, relatively soon, like a week and a half or so, where the clerk will send in fact, inform you who the mediator is, and then you can make contact and set up a time to meet with the mediator then.
Okay.
The court will set February 3rd, 2025 at 1:30 p.m. as the settlement conference date. Parties are required to be there unless we've come to a full resolution prior to that time. So there are other dates and things in the case scheduling order that you'll get as far as things that need to be filed: witness list, exhibit list, property divisions. Well, it wouldn't be property division, but any of those other charts you'll have to file in this particular matter by the date set forth in the case scheduling order. If you don't file those, that could have adverse consequences to your case, because you may not be able to get exhibits in that you want in, or you may not be able to get people to testify if you have not properly disclosed those. With that, Mr. Richardson, do you have any questions?
No.
Okay. Ms. Stout, any questions?
Not as far as the case goes as of now, but is there anything that we can do prior to the court date? Because Mr. Richardson is withholding Alexis from me. I have not spoken or seen my child in over a month.
Yeah, what you can do is you have a right to, you can file a motion, and a motion is just a request to the court. We hear those on Monday, and
Okay.
you can schedule those. I would tell you, schedule them at like 10 or 10:30 a.m. because the attorneys they usually schedule theirs for 9 or 9:30, and it'd be backed up. So if you schedule it, you'd be sitting waiting probably until about 10 or 10:30 anyway, because of the volume of motions that the attorneys file. So you can file that, make your request, and that would just be a Monday morning hearing.
Okay. Okay.
Anything else?
Nope.
Okay. Thank you. You're free to go. Have a good day.
You too. Thank you.
All right, thank you.
Mr. Deskins, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charge?
Yes, sir.
Court has appointed Ms. Perkins to represent you. Have you had sufficient opportunity to speak to Ms. Perkins in preparation for this hearing?
Yes.
Okay. And Ms. Perkins, are you ready to proceed?
Yes.
Okay. What I'm going to have to do is Ms. Tolf and Ms. Deskins and Mr. Deskins, I'll have you each raise your right hands, be sworn in, then we'll take some testimony from you.
All right. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Oh, okay. Thank you. Ms. Tolf, you can proceed.
Thank you, Your Honor. Before the court today is Joshua Deskins. We're here on both cases today for adjourned compliance hearings. On docket 2007-731 DP, the respondent's total monthly obligation is $167.50. This comes from $114 for current support. He is ordered to pay $50 per month on arrears and $3.50 per month on service and processing fees. Last payment we received on this docket was a $500 bench warrant resolution payment on July 25th, 2024. In this case, it is the 7th show cause. He's had 5 bench warrants and 2 prior contempt findings. Monitoring compliance for the last 6 months at a rate of $167.50 means he should have paid $1,005, and he has paid nothing outside of that 1 bench warrant payment, making the shortfall for the last 6 months $1,005. Total arrears on this case are currently at $6,901.33 through the end of September 2024. On docket 2022-3260DS, Mr. Deskins' total monthly obligation is $408.50 per month. This comes from $331 for current support, the guideline amount of $74 per month toward arrears, and $3.50 for service and processing fees. Last payment we received on this docket was a $200 bench warrant resolution payment in July of 2024. This is the first show cause. He's had 2 bench warrants and no contempt findings on this case. Monitoring compliance for the last 6 months at a rate of $408.50 means that he should have paid $2,307, and he paid nothing outside of that bench warrant payment, making the shortfall $2,307. Current arrears on this docket are $3,713.06 through the end of September. In front of the court would like your honor to be aware that the respondent had previously been ordered into LEAP and failed to participate. He failed to provide medical documentation when he previously stated that he was unable to work. He has failed to take action by filing motions to modify support in either case. And he did state to me that he has been working under the table doing odd jobs, working on cars. He did just report that he is now employed at Checkers Automotive, but he had previously told me that he was working there under the table. This matter has been adjourned many, many times to allow the respondent to get in compliance, file motions, submit medical documentation, etc. He does have the ability to work and be paying on these cases. Thank you.
Okay, thank you. Ms. Perkins, do you dispute or contest any of the statements made by Ms. Tull?
No, Your Honor.
Do you have any questions for Ms. Tull?
No questions.
Okay. Any proofs, Ms. Perkins?
Your Honor, I'd like to call Joshua Deskins.
Okay, go ahead.
Mr. Deskins, can you please state your name for the record?
Joshua Deskins.
And you heard everything that was just said, is that correct?
Yes, ma'am.
Is it true that your last payment on both of these cases was on July 25th of this year?
Yes, ma'am.
And what's going on that you're not making regular payments?
Well, I didn't make regular payments because I was talking to him last about my warrant. I had just borrow this money from the guy I'm working for right now to get out of jail. And I told him that my son wasn't in school. My son's 17, which has got guardianship of me, part of the guardianship of me, since how he's my oldest son. And I shouldn't have to be paying him child support. Why they control my phone, control everything. And I can't even make court dates, so they make sure I'm asleep when it comes up court date, because they obviously control my whole life. They're my guardians. I can't divorce my wife because it takes the third party to be able to do it, because I can't make decisions for myself, which my wife was part of the ones too. So I'm paying her child support. I can't divorce her. And the kids, I don't even think are mine. And I'm having to pay child support to them too. And they still continue to, even though my son's not in school and he's 17, he's my oldest one now, he's a legal adult, I'm still having to pay child support every month, continuous on them too, which I made a report back 5 or 6 months ago about that. And yeah, and since how I do have involuntary guardianship been took over me, I can't make decisions for myself. I shouldn't be able to work and stuff like this because I can't manage nothing by myself. Courts already know that I can't manage by myself. And that's why somebody took guardianship of me and had the judge sign it. I wasn't voluntary guardianship of me. But since how that is the case, why am I going to jail for child support every other day too? And that's what my argument about it was. I don't mind paying the money to do it, but I'm legally married to a woman that only thinks my kids, and I'm having to pay her child support, and she's my guardian too. I don't really understand why I would have to, since how they control everything. And obviously I can't work because the state already says I can't. I can't manage nothing. So why am I having to go to jail? And it kind of breaks my heart a little bit about it. I don't understand why everything one after another for the same people that's got a guardianship of me. It didn't make sense to me. And that's where I was at with it. I shouldn't. I feel I shouldn't have to supply paperwork and do all this, and I can't even get half the paperwork I need because my guardian has to do it. I can't do it. So there's really nothing much I can do since I have a guardian. And I'm kind of tired too. I don't know what to do no more. I don't.
Have you asked your guardian to get the paperwork for you?
Not all of them keep ignoring me about it. Like, I don't know what you're talking about, and due to protection of myself or others, they don't want me to know who exactly my guardian is, even though it took my two oldest brothers and my wife first that did it. And for retaliation purposes and for safety purposes, the courts won't disclose that to me. And they did it from a different county instead of Calhoun County too. And I can't do nothing. I can't even divorce. I keep getting denied everything. I don't know. I come out of prison and they did it to me. They said I was a threat to myself and others. So fresh out of prison, they did this stuff to me. It's been going on for years. And I can't do nothing, really. I ain't got no rights. I can't do nothing. I don't mind paying a little bit of money, but I should have to pay for money for a kid that's my guardian. That's still currently paying child support every month for, and it ain't just arrearages. It's every month I'm paying them still child support for the person that's controlling my life. Like, come on.
Is it true that you're working for Checkers Automotive?
Yeah, I just started Friday. I was doing the job. I didn't tell her I worked on a table. That was not true. I said I work jobs every now and then. I go there and I fix the cars. I each carburetor. I do little things for him. And he pays me a little bit of money for gas and for food and stuff like that. But he hired me Friday, so I'm gonna have a steady employment from him. Yes, and he was the one that kept paying my child support, and I was always indebted to him to pay it off because he kept getting me out of jail every time I went. So
from here on out, you should be getting a steady check. Is that correct?
That's correct.
And Ms. Tulf indicated that you refused to participate in the LEAP program. Is that correct?
I didn't even know what the elite program was, but I've seen how I was doing the side jobs with them. I didn't end up going. It's just like, I don't know. I've been feeling like mostly depressed most of the time. I got a lot of issues. Obviously, the courts already know about since the guardianship, they know my mental health issues and me sleeping a lot or me, kind of being irritated at myself or whatever. My mental state really doesn't matter. But yeah, I've been going through a lot.
Okay.
And I kind of want to be myself most of the time now. So.
Okay. Did your did Miss Tulf ever ask you for any medical documentation with regard to your ability to work or anything along those lines?
Yes, I went down I got some paperwork for her. I was going to take it to the medical doctor at Summit Point, and me and Summit Point I ended up arguing with Summit Point actually, and walked out on the same door and walked out on them. I kind of threw a fit, to be honest with you, over them. And it's because I don't know, I've been going there a lot, and he keeps trying to say like a couple more weeks or come and see the psych doctor, and that's the ones that deal with the courts, and then we can get it taken care of. But then they delay it and they push it, and it's just like they're doing it on purpose almost, just to like, I don't know. I really honestly don't know. So I kind of got mad. Yeah, and I said, if they know the documents, they should be able to. They should know that what the guardian person is, and they should know can't charge a person when certain kid's not in school. And I make it known to the courts already he's not in school. It's not the court's job, but it's the prosecutor's job, or it's the ones that's enforcing the payments job to see, hey, is he really in school? Because we can't charge this man if he's not in school no more. The kid we can't continue to charge this dude month. But they did anyway. They didn't care. Now they want me to go prove it when I'm already can't manage and take care of myself on top of that. And why should I have to prove? I didn't prove to make you pay this. Why am I have to? If I'm making known to you this is what's going on, why are you still continuing to charge me without verifying it? And it's that's how I felt about the situation. I have to go to the doctors. I have to go get this verification from schools, and I have to do all this. And then they're like, "Well, who's your guardian?" You know what I'm saying? Then I can't get it anyway because I'm not the guard. My guardian has to get it. So now I'm stuck in another root, and the root it goes forever about how difficult this gets for me, to be honest with you. And I didn't know I had to fight to do this because I didn't enforce me to pay my money. And I don't know if I should pay when a kid is not in school no more. I thought that stopped. So yes, all this paperwork she wanted me to go down there and get, half of it I couldn't get anyway. And then the other half of it is I shouldn't have to go around my head chopped off and people doing this to me back and forth, not giving me answers, giving me paperwork. And then I'm with nothing, just holding my hand, and I know where the rabbit hole just goes around the circle. So I'm giving up. I've been giving up a lot. And,
is there anything else that you want to tell the judge?
No, that's kind of about it. Other than I'm I'll pay the monthly payment that I have to pay or whatever it is that he sends me to or to pay. I get done Friday is when I got my job, so I'll have a steady income and I can make a certain amount for the rearages and whatever else I have to pay for the child support.
Okay, thank you.
You're welcome.
No other questions, Your Honor.
Okay, thank you. Well, just to clarify some things for you, sir, because you seem to be relying upon the fact that you have a guardianship as to why you can't do anything. There's a lot of reasons for a guardianship, and just because you have a guardianship doesn't mean you can't work. It doesn't mean you can't function. It just means that you need assistance at times for various reasons. There's reasons that they appoint a guardian, and it doesn't mean that you're totally disabled because you have a guardianship. And in fact, as you see, you're working at Checker Automotive, so clearly you can work, notwithstanding having the guardianship. As well as the other ones, like you said, as far as your son, you have a right, and Ms. Tolf has told you, you have a right to file a motion to terminate that support, but you have to take the initiative to do that because the court doesn't know what's happening. The court doesn't know he's not in school. The court doesn't know his age, etc. So you're the one that's going to have to initiate and do the paperwork. That's why she's referred you to the clerk's office to get that paperwork to file so that you can avoid that support obligation if in fact you're entitled to do so. But you're required to do that, sir. Nobody else is. How much are you making at Checker Automotive?
I'll make about 600 a week, 700 a week. If I work, 6 days, I usually would probably be starting off at working 6 days.
Okay, so you're looking at 600 a week?
Yeah, if it's about 6 days, yeah.
So clearly you'd be able to pay your support obligation because your support obligation is about $570 then between the two cases. You did have, as Ms. Tolfett stated, you did have, previously you had odd jobs that you were working for Checker and for someone else. Is that correct?
Just that he'd call me, a couple times every other week and have me come and change something on a car, something really simple, maybe a flat tire that was in the parking lot, go out there and take it off and take it down to the shop and have them change the tire on it, like little petty jobs like that.
Okay. And how much would you say in an average month did you make when you were working odd jobs?
$60 sometimes 3 weeks before he calls me. He called me more that he had to get me out of jail last time, or paid to keep me out of jail, and he had me working a lot more often then because I owed him the money.
Okay. You said as well that you're not familiar or you don't know who your guardian is. You can go to the court and you can find out who that is because there would be an order appointing a guardian. So there would be an order that you could look at and that would tell you who the guardian is. And then you can make contact with them if you need to do so.
How do I figure out which county it was from?
I have no idea. If you reside in Calhoun County all along, it should be Calhoun County. If there was another county that you resided in at some point, it might be that county. So you're the one that knows where you lived and when you lived. And if you know when the guardianship was put into place, if you live, let's say, in Eaton County, at the time the guardianship was put in place, then that's where you would probably go because Eaton County would have all the documents, etc. Even though you move, it would be the county that you resided in at the time that the guardian was appointed. So you have to figure out where you were residing at that time and go to that county. You may have to go to two counties. I don't know if you're uncertain or whatever, but
okay, I got you. I think I know.
okay. Sir, in the last, let's say in the last, this year, what have you done to acquire employment?
I ain't done much other than doing my odd jobs I got out of the hospital. I went to the hospital about a month and a half ago for overdosing. I was on drugs probably for the past 4 years and continuously doing drugs every day. I've been clean for about 45 days now, and I'm feeling much better with myself. But my mental health and my drug addictions was the best part of me up until 45 days ago. And right after I OD'd in the hospital and woke up in the hospital, I haven't done no drugs since then. So I've been clean. I've been just now getting my life back on order. So I really didn't do much of nothing but drugs most of the time.
Okay. Anything else that you'd like me to be aware of, sir?
No, sir, that's it.
Okay, thank you.
You're welcome.
Ms. Deskins, anything you would like me to be aware of?
Yes, Your Honor. I just want to state the fact that he's lying. He's worked for Checkers Automotives for the past 2 years. And every day he texts my phone asking me if he could see the kids. So if they're really not his kids, then why does he want to see them? Why does he want to come and sit here and irritate me and bother me and cause me heck in my life to see my kids if they're not his? That's kind of where I'm at with it. This is what I want. I wish that he would just leave me and my kids alone. If I could drop the child support, I'd be more than happy, but I want him to stay away.
Okay. Well, ma'am, you have every right to, in your particular case, you can always forgive the arrearage if you want.
I did that.
Unless you're on any sort of public assistance. If you're on public assistance, you cannot waive that.
I get food stamps.
Yeah, you can't waive it then, and you can't waive the support obligation if you're on public assistance. So
if I stop my food stamps and I stop my medical, I can just drop the child support and maybe motion to leave the state to get away from him.
Sure. You can file a motion to do whatever you want. Doesn't matter, it'll be granted, but you can file the motion, and if you have a basis, you can do that. And you would have to be off public assistance to be able to waive the arrearage and to waive any current support obligation.
Okay, I'll have my I'll have my food stamps and my Medicaid stopped.
Well, that's up to you, ma'am. You don't have to. I'm just, if you wish to do that, you have a right to do that.
Well, yes, Your Honor, because I'm tired of dealing with Joshua. I don't want to deal with it no more. It's been nothing but problems. He causes nothing but problems.
Okay, well, again, you can do it if you wish, and but that's up to you.
Okay.
Yeah, once you're off the assistance, you have to file the appropriate motion with the circuit court clerk's office.
Okay, I can do that.
Okay, thank you.
Thank you.
Anything else, Ms. Perkins?
Your Honor, I just want to point out that my client did indicate that he just started working Checkers this last Friday, so he hasn't gotten a paycheck yet, but he's going to. What we're asking for is that you adjourn this out to give him time to set up income withholding so that he can make those child support payments.
Okay. Well, in this case, the court has heard the testimony of Mr. Deskins, and it's clear, as he stated, he did have a drug problem, and that, as he stated, he basically spent most of his time doing drugs and not working. And as he said, when I asked him what he had done in the last year to apply for employment, he says he hasn't done much. And clearly from his testimony, it's clear that he hasn't done much. He has the ability to do so because he's working now. He has worked odd jobs throughout the last year. And the court will find that he has had the present ability to pay support obligation, but he's failed or refused to pay. And that as a result, he is in contempt of court. So the court will so find in this matter. Anything before sentencing, Ms. Perkins?
No, Your Honor.
Well, in this particular case, you have a minimal support obligation. Apparently you're working now. That helps. That's good. What the court's going to do is, Ms. Toff, what was the previously been held in contempt on 2 occasions? What was the last sentence?
Let me look for you. It looks like the last contempt finding, was in 2018.
How much was it for, do you know?
And no jail time was assessed at that
Okay.
time.
Okay. Well, what the court's gonna do, Mr. Deskins, I am going to, I could sentence you up to 90 days in jail. I'm not gonna do that. I'm gonna sentence you to 45 days in jail with credit for no time served. The court is going to put in this matter, the court is going to give you a nominal amount because you've just started working. I'm going to let you pay a purge amount, meaning you amount to stay out of jail, and you'll have to pay that purge amount within 2 weeks, and I'm going to have you pay $200 on each case. So it'd be $400 total, and you'd have to pay that no later than October 30, 2024. And what I'm going to do as well is I'm going to suspend the jail time and have you back in court on December 18 at 8:45 a.m. And what we'll do is we'll look at it. In the meantime, if you paid the purge amount of the $400 and you are paying your current support obligation up through the December 18th date, then the court will consider, again, continuing the suspension, keeping you out of jail. I will tell you, if you don't pay the purge amount and you don't pay the current support obligation, then you will be spending the 45 days in jail. Do you understand that, sir?
Mm-hmm.
Okay. We will then see you back on December 18, 2024 at 8:45 a.m.
All right.
Free to go. Have a good day.
All right, thank you.
All right.
All right, thank you, Your Honor.
Yep.
Can you hear us?
Yes.
Okay, let's
Okay.
go to the next case.
Mr. Cantrell, in this matter, you're before the court charged with civil contempt of court due to your failure to appear, your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes.
Court has appointed Ms. Perkins to represent you. Have you had sufficient opportunity to speak to Ms. Perkins in preparation for this hearing?
Yes.
Ms. Perkins, are you ready to proceed?
I am.
Okay. Mr. Cantrell, I'll have you raise your right hand. Ms. Brown, we'll have you both sworn in, then we'll take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Yeah.
Okay. Ms. Brown, you can proceed.
Thank you, Your Honor. Before the court is Loewyn Cantrell on docket 2016-55DS. He's before the court for a compliance hearing. Mr. Cantrell has a monthly obligation of $291.50. His last payment was April 19th of this year. It was through income withholding, and it was in the amount of $67.01. He's had one prior contempt finding. For 3 months of compliance, Mr. Cantrell should have paid $874.50. He's paid nothing. Total arrears are $13,681.50. Just for the record, Mr. Cantrell had a bench warrant hearing back in May, and he and I met, and that matter was adjourned until July. I spoke to Mr. Cantrell again in July. At that time, he reported working, driving delivery, but there have been no payments made since April.
Okay. Ms. Perkins, do you dispute or contest any of the statements made by Ms. Brown?
No,
Do you have any questions for Ms. Brown?
no questions.
Okay. Any proofs, Ms. Perkins?
Your Honor, my client has had a really rough time of it for the last 6 months. In April, he was evicted from his home. He had to stay with his fiance's parents. Then they were able to find another home, and they've been struggling with that since then. They also had an eviction notice with regard to that case because utilities were taken from them from the past place that they were evicted, and when that happened, the check for the rent bounced, placing them in an eviction status with the new place. They had to work things out with regard to that landlord to try to keep that home. They are still doing that with a payment plan of the rent owed plus their current rent. My client was in a car accident. He didn't have a car, so he was having troubles with working with regard to that. When he did finally be able to buy a new car, that car broke down. So they had to find another car so that he could try to work. He is working with DoorDash. Unfortunately, it's been very slow. There's been a time where he couldn't keep his phone on for a month because there was just no money to pay the phone bill. When there was no money to pay the phone bill, he couldn't work. There are times that DoorDash has jobs in Kalamazoo that he can't get to because he doesn't have the gas to put in the car because he doesn't have the money. He's in this vicious circle of he needs money to make money and he doesn't have the money to make the money. He's tried to do work in factories. However, he's got some medical issues with regard to his back that does not allow him to work for long periods of time. So he's unable to do that. He has filed many applications to retail stores, dispensaries. He's had interviews, just no one's calling him back from any of that. He's even thought about moving out of Battle Creek to try to find a job somewhere else because he's just having a really tough time with finding a job here. He's got several applications that he's currently waiting on to hear. Some in the Albion area. He's branching out wherever he can to try to find work. The problem is he's willing to work. He's just not able to find a job, and he wants to pay this money. He does not want to be behind. He wants to be able to pay it. And it's just the last 6 months have been very difficult for him with one thing after another hitting him. And he's trying to put those fires out. He's barely being able to take care of himself, let alone anything else. What we're asking for you today is that you adjourn this case out, that will give him the opportunity to hear back from those applications, and hopefully one of those applications will end up in a permanent job that's a little bit more lucrative than DoorDash has been since it's been so slow lately. Thank you.
Okay, thank you. Mr. Cantrell, in this matter, you've heard your attorney and all of that. Obviously, she's given a scenario of some very, some difficulties you've had in the last 6 months, but you understand you haven't paid any support. So the mother of these children is probably having difficulty too. You understand that?
From my understanding, Your Honor, the quote unquote child support that I'm paying does not go to the mother of my son.
Okay, well, in any event that she's supported on public assistance, so the general public is paying that, and the other amounts are just to reimburse the state for all of the money that's being paid to her. So regardless of if you pay it direct or it comes indirectly, if you're not paying, she's not getting her money. You understand that?
I understand that, Your Honor. I also understand that if that were the case, I'm not even allowed to see my child, which was never a court order.
Well, there's a process for that. If you want to see the child, you can file a motion in your case, and provided that there's no reason that you shouldn't, the court can always order a visitation with the child. So the fact that you're not seeing the child is not an excuse for not paying child support, because you have a right to petition the court and seek to see the child if you wish to do so.
Okay.
What have you done other than the DoorDash, let's say in the last, in this year, 2024, where have you worked?
I worked with on staff for a little bit at TRMI. I worked at Dish Traders as a team lead for about a month. Other than that, I can't, off the top of my head, recall anything within this year that was a good lucrative job. I tried doing like odd jobs and, side jobs, just to at least put food on the table. At this point in time, I would say that I've been contemplating going back to the military just so I could pay this.
Well, that's always an option that you have. So during this time, you had been working odd jobs, been making some money. On your odd jobs, how much would you say you made on average per month?
$50 to $100.
How much?
It's usually just helping. About $50 to $100. It's usually just helping someone move something or something like that.
Okay. And how long were you at TRMI?
I want to say 2 months, and then my back gave out. I was in and out of the doctor's office throughout that entire time.
And how much were you making at that time in a given week?
That one was a pretty good job. It was, I think, around $18 an hour. So I don't know what that would be after tax at 2 weeks. Not too good at math.
Okay. And likewise, you said about a month you're at Disc Traders, is that correct?
Yes.
And how much did you make there per hour?
That was low wage, $12 an hour.
And why did you leave that employment?
For possible legal reasons that I do not know about. I can't say everything, but just there was a big dispute between me and my manager and some activities going on at the workplace.
Okay. Anything else that you'd like to tell me, sir?
Nothing other than the fact that I have been trying very hard. I find myself in a situation where I feel like and think that there's not much opportunity for me around here, which is why I can't find work, adequate work. Which is putting me in a bit of a mental state that it's not healthy. I do have a history of PTSD and things like that. So this is stressful, but I'm trying my hardest to work it out.
Okay. Well, in this case, the court will make the following finding. The court's heard the testimony from Mr. Cantrell that he stated that he, again, had worked for approximately 2 months at TRMI. He'd worked at Disc Traders for about a month. He was making respectively $18 an hour and $12 per hour in both of in those particular jobs. That obviously he was also working part or odd jobs where he said he made only minimal $50 to $100 per month, but he did have income with which he could pay his support obligation, and he had not done so in this matter. The last payment being in April 19, 2024, when he was employed at one of these particular jobs, and he has not paid anything since. In this case, the court will find that he's failed or refused to pay, and he's basically has not complied with the order of this court, nor has he made a good faith attempt at compliance, and therefore the court will find him to be in contempt of court. Anything before sentencing, Ms. Perkins?
No.
Okay, thank you. Sir, you have a prior finding of contempt. The court could sentence you up to 90 days in jail. I'm not going to do that, but the court does note that you have an arrearage just under $14,000 when you consider that your monthly obligation is only $291.50. That's pretty substantial, shows a pretty substantial period of time where you have either ignored or failed to comply in this particular case. So what the court is going to do is I am going to sentence you to 45 days in jail with credit for 0 days served. I'm going to allow you to purge yourself of contempt by paying the sum of $500. I'm going to give you until November 1 at 4:00 p.m. If you pay the purge amount by that time, then you do not have to go to jail. If you don't, then you're going to have to report to jail on November 1, 2024 at 4:00, before 4:00 p.m. And I will tell you, if you don't report and you come back before the court, that you could end up spending more time in jail. So that's up to you, but I've given you that 2 weeks to attempt to raise the money to purge yourself so you don't have to go to contempt. Other than that, you're free to go, sir. You have a good day.
That's all I have. Thank you.
Okay, thank you.
Yes, I can.
Okay, we're ready for you.
Right. Ms. Sutherland, in this matter, the court will advise you ever that, again, you're charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, I do.
Court would advise, in this particular case, the court has appointed Ms. Perkins to represent you. Have you had sufficient opportunity to speak to Ms. Perkins in preparation for this proceeding?
Yes, I have.
Ms. Perkins, are you ready to proceed?
Yes, I am.
Okay. Ms. Mouton, Ms. Sutherland, I have you raise your right hand, be sworn in, then we'll take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay.
Yes, sir.
Ms. Mouton, you can proceed.
Your Honor, in the matter of Grzinski versus Sutherland, docket 2018-3208 DC, the respondent Ashley Sutherland is here for a bench warrant hearing because she failed to appear for a show cause hearing on March 26, 2024 before referee Moeller. Ms. Sutherland is currently ordered to pay $141 a month for current support, $50 on arrears for a total of $194.50 each month, including service and processing fees. Last payment received on this docket was on June 15, 2022, in the amount of $260. And to be clear, Your Honor, that was the last voluntary payment received. Ms. Sutherland did post a $100 bond on September 27, 2024. This is her third show cause, second bench warrant, and she's had no previous findings of contempt. I measured compliance over the last 6 months. Ms. Sutherland should have paid $1,167. She's paid nothing, so that is also her shortfall. Total arrears on this docket are $972.78 through September 30th, 2024. And Your Honor, Ms. Sutherland does have credit for 1 day served in jail.
Okay.
No,
Ms.
bonded
Perkins,
out on
do
the
you
28th.
contest or dispute any statements made by Ms. Mouton?
Your Honor, my client has indicated that she has made payments this year, one around March for approximately $147 and another one in June and for approximately around $40. Also, my client indicates that on the March 26th court hearing, she did show up to it, but she was late to it. There was a bench warrant already being issued, but when she talked to the referee, that referee indicated to her that he was going to undo that bench warrant since she did show up to that hearing date. And in fact, that was around when she made that payment, and then she showed up a couple of weeks later for more court hearings with regard to her children. And she wasn't arrested at that time, so she felt that the bench warrant was in fact taken care of like she thought it was. She also called down to court to make sure there was no bench warrant. They indicated there was no bench warrant for her. So we do contest those issues with regard to the FOC enforcement. Also, there is a question of why the total arrears is lower than the total shortfall. That does not make sense to either one of us.
Why is the arrearage less than the shortfall?
Yes.
Well, probably because she was ordered to pay a particular, maybe a lump sum amount, plus the ongoing support obligation, so that might have been higher than the arrearage, because she was ordered to pay that particular amount.
Usually, Your Honor,
I was never.
that's outlined under the lump sum so that we would know that's where it's coming from, and it does not show that here.
Okay.
Your Honor, may I?
Yes, go ahead.
So we have, friend of the court has received some involuntary payments, which would account for the difference in the arrears and what is currently the shortfall. But again, the last voluntary payment received was in 2022.
Okay. Does that help you, Ms. Perkins?
My client has indicated that the payments she made this year were voluntary payments that she did make.
Okay, well, that would be subject to an audit, so that maybe that's something that she has to request and check on and see that. Anything else, Ms. Perkins? Any questions of Ms. Mouton?
No, I have no questions of Ms.
Okay. Any proofs, Ms. Perkins?
Yeah, Your Honor, on top of all that I have already indicated, my client is currently not working. She's been out of work for about the past 4 years. The reason being is her youngest child had severe medical issues where the child needed to be taken care of 24/7 full time. That's what she was doing. That child is now residing with her mother because CPS got involved. So since that time, she's been looking for work. She's had interviews with Magna and TRMI. She's not heard anything back from those interviews. When she called to check up on it, they said that somebody else got the job. She's on waiting list for 3 different staffing agencies to try to get work. She calls on that regularly. They indicate that she's still on the list. They're just not getting a lot of openings. She's also dealing with the court for CPS and doing a lot of classes with regard to that, so that she can get her kids back into her care. She's had to move her residence, so she's had a very stressful time, but she's still trying to, find a job and get this paid. She does not want to be behind in her child support. She was able to bond out. She's able to she wants to be able to pay the like $20 a week to get something paid towards the child support to give her more time to try to find a regular work. And recently her child support was dropped down to the 147. Prior to, it was like 400 plus that she was not able to make those payments, but that has been changed. So that is going to help her, but she's still needing the time to find work. And we're asking that you adjourn this out to give her that time.
Okay, thank you. Ms. Sutherland, in this matter, your attorney had said basically that the child now is with your mother. When did the child go to live with your mother?
CPS got involved last August with me, but during that process, I've had to move. I've had.
Okay, but hold on. I asked you one simple question. When did the child go live with your mother?
They've been with my mom since August of last year.
Last year to 2023?
Yeah.
Okay. Okay, then tell me, in the last year, what have you done to acquire employment?
Well, I've put several applications in. I mean, multiple places. I mean, pretty much every place on Columbia, I put applications in. I went to temp agencies. I've had interviews, but there was people that met higher qualifications than I did, so they got the position before I did. Like my attorney told you, I'm on the waiting list at 3 different staffing agencies, and I call them regularly. I did have a job back in May or June, and I was working for a construction business, but he failed to pay me, only paid me $170 out of $2,400 that he was supposed to pay me, so I quit there. And ever since then, I've been having a hard time finding a job. I put applications in pretty much every day.
Okay, let's say
online, in person.
In a given day, how many applications would you put in?
At least 1 a day. But there's days where I sit online all day and put applications in.
Okay.
through
well,
Indeed,
okay, hold on.
ShiftSmart.
Hold on. You said you put in one a day. You realize you could put an application in 15 minutes someplace. So it's not that it's taking up your whole day to put applications in.
No, but I also don't have a vehicle either.
Okay.
And I live in Dowling.
Well, that's probably a substantial hindrance if you're trying to get a job and can't drive or don't have transportation. You live in Dowling because last time I was aware, they don't have a lot of industry in Dowling.
Right. I've been putting applications in Battle Creek though.
Okay. Why haven't you moved? Why haven't you moved to Battle Creek where you could utilize public transportation or move closer to where you might be able to get a job?
Because I've lived in Battle Creek for 35 years and it's toxic for me. That's why I moved out of Battle Creek. There's nothing good there for me. It creates nothing but problems.
Okay.
I want a better life. I want a better lifestyle for my kids. I don't want to be in Battle Creek.
Okay. Well, there's other communities you go to. You could move to Kalamazoo. They have a lot of jobs over there. Or you could move to any number of cities other than Battle Creek to acquire employment. Why haven't you done that?
Because I don't want to live in Kalamazoo. I moved to Dowling because I wanted to live in Dowling out in the country. I don't want to live in the city.
Okay. Well, if you have transportation issues, you're not going to find jobs out in the country somewhere. You understand that?
I can get transportation, but I mean, I can't drive around every day and put in applications. I do them online. A lot of places don't even do paper applications. You have to do them online anyways.
Ma'am, what's your education background?
I have a high school diploma and 2 associate's degrees.
With those credentials and 2 associate's degree, why do you feel you haven't been able to acquire employment?
Because my degrees are in cosmetology and instructing to teach cosmetology. I had a knee injury and it's hard for me to stand up for hours on a concrete floor. My whole leg swells up. I have pins and screws in my knee. So standing for long periods of time on a concrete floor hurts me.
Okay. Anything else you'd like me to be aware of, ma'am?
You're saying that I was only in jail for 1 day and that's false. I went to jail on September 26th and at like 5 o'clock in the morning. I wasn't bonded out until 5 o'clock on the 28th. And the same day that I went to court in front of the same judge on September 25th. I went in front of him for like 3 hours. I was in court with him. The same magistrate, the thing that issued my warrants. I've been in front of this magistrate several times over the last 90 days dealing with my case with CPS, and nothing's ever been said about me having warrants.
Okay. Well, I can't say what another judge has done. I don't know what else is, what else is in your record, but the fact is what happens if you were in jail on another matter, you wouldn't be getting credit for this case because you were in jail on another matter.
No, I wasn't. I was in jail on child support, but I went in front of the magistrate the same day that I got arrested. I was in court with that same magistrate that issued the warrant supposedly back in March.
Okay, and I'm saying that would have been in a different matter, only because if you would have been at a bench warrant with me, you would have been before me, ma'am, and I would have again addressed the matter at that point. So you could have been in jail on something else, so you would not be entitled to credit in this case if you were in jail on something else.
I wasn't in jail for something else. I was in jail on what I'm going to court for today.
Yeah.
I went to court on September 25th in front of that same magistrate. At 5 o'clock in the morning on the 26th, I got arrested for 2 bench warrants from that same magistrate on child support, but I was in front of him 16 hours prior to.
Okay, well, you'll have to look into that because I have no idea about that. All I can go is based upon what information we have, ma'am. Anything else you'd like to tell me?
No.
Okay. Well, in this matter, the court's heard the testimony that Ms. Sutherland has testified that, again, it looks like she has a nominal support arrears. It's under $1,000. That, again, that she claims that she's made 2 payments this year, that the records only show that the last voluntary was back in 2022. June of 2022, but again, that there have been some involuntary payments. She states that she had issues with a child that needed some 24/7 care, but that child has been out of her care since August of 2023, and that she also testifies that her support obligation was reduced previously because it was substantially more, and it's been reduced down. The court notes that it is a nominal amount. It's $194.50 per month. That she did have a job up through approximately May or June of 2024, but had some problems with her employer not paying her, and then she quit the job at that particular time. She lives in Dowling, which she states is out in the country. It is. There's very little, if any, opportunities to get employment in that area, and she doesn't want to live in Battle Creek because she claims that it's toxic in the time she's living, but yet she doesn't want to live in Kalamazoo where she could acquire employment as well, that she wants to live in the country. And obviously that presents a minimal opportunity for her to acquire employment because there's minimal jobs available in the country. The court will find that, again, that she has not exercised good faith attempt at compliance. She's failed or refused to comply, and she is in contempt of court. Anything, Ms. Perkins, before sentencing?
No, Your Honor.
Can you let him know that about my classes, that it's going to stop me from complying with my other children?
Is what? I didn't catch that, ma'am.
If I go to jail, then it's going to put me in non-compliance with CPS, and then it's going to terminate my rights with my other children if I go to jail. Because I'm not going to be able to do my services for CPS.
Well, you'll have to contact CPS. They do have ability to offer those services in jail if you're in jail. So that's what you'll have to do with them. Based upon the amount in this matter, the court will forfeit the bond previously posted in this case to be applied towards the arrears. That brings it down to, at that point, under $900. We could sentence you up to 45 days in jail. I'm not going to do that. Court is going to sentence you to 14 days in jail with credit for 1 day served. The court will allow you to purge yourself of contempt by paying the sum of $300, and the court will delay the sentence in this matter to November 1, 2024, that you'd have to report before 4:00 p.m. And that way, if you pay the purge amount of $300 before 4:00 p.m. on November 1, 2024, you would not have to spend the remaining 13 days in jail. Do you have any questions, ma'am?
No.
Okay. That will be the order of the court. You're free to go today, and court will let you know. You either pay the purge amount or show up on the November 1 date. If you don't show up on that date and you come into court, the court could sentence you in this particular matter for contempt of court for not showing up to 90 days. So it's best that you take care of this before November 1.
Okay, thank you.
There you go. Have a good day.
You too. Thank you.
All right.
Thank you, Your Honor. That's all I have today.
Okay, thank you.
You're welcome.
All right.